The U.S. Supreme Court made a 5-4 decision in Obergefell v. Hodges on June 26, 2015, that state bans on same-sex marriages and on recognizing same-sex marriages are unconstitutional, for the right to marry is protected under the Due Process Clause as well as the Equal Protection Clause of the 14th Amendment. It all started with James Obergefell and his partner John Arthur. They both wanted to get married due to John's illness known as ALS. Due to it being terminal, John wanted to have James as his living spouse on his death certificate. And in the state of Ohio, same-sex marriage was prohibited. Took a plane and got married in Maryland. When John passed away, however, the state of Ohio did not want to recognize James as a valid spouse. Therefore, he sued the state. Same-sex couples around the country were suing their state agencies for similar reasons. States such as Ohio, Michigan, Kentucky, and Tennessee wanted to challenge the constitutionality of the unacknowledgement of same-sex marriage, which eventually accumulated into Obergefell v. Hodges. Facing lengthy series of appeal courts, the Sixth Circuit ruled the bans constitutional, which created a split between circuits, leaving it to the Supreme Court. The majority opinion was authored by Justice Anthony Kennedy, stating that the court majority held the state bans on same-sex marriage is a violation of the 14th Amendment due process and equal protection clauses. The Constitution promises liberty to all within its reach, the court declared, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity. Along with this decision, the court listed 4 distinct reasons on why marriage is a fundamental right, as well as citing cases that were relevant to the case. First, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Second, right to marry is fundamental because it supports a two-person union. Third, it safeguards children and families. Fourth, marriage is considered a keystone to social order and that is no different when it comes to same-sex marriages. Citing Griswold v. Connecticut, the court declared that the rights that are tied to the 14th Amendment include choices that are made that are central to autonomy, including intimate choices that define personal identities and beliefs. As the Supreme Court has found in Loving v. Virginia, Zablocki v. Red Hill, and Turner v. Safley, the identification and protection has not been reduced to any formula. In conclusion, Kennedy wrote, "No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were. As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eye of the law. The Constitution grants them that right."